Good morning, all, and welcome to the Friday morning Miller-Johnson webinar. This is Sarah Willey, and I'm here with my colleague, Sandy Andre. We're going to be talking to you guys this morning with a revised list of top 10 questions from employers about COVID-19. Some of you may remember, gosh, I think it was 3 weeks ago now, Friday the 13th, Sandy and I kicked off our very first Miller-Johnson COVID-19 webinar, and we called it Top 10 Questions from Employers About COVID-19. So much has changed in the last 3 weeks. For some of us, it feels like that was 3 years ago, quite frankly. So Sandy and I thought it would be both fun and very helpful for all of you to redo those top 10 questions and talk about what employers are asking now about COVID-19. So thanks for joining us. We're going to cover what I think is the waterfront for probably what you guys are wondering about now. We're going to cover positive tests, what to do when somebody tests positive in the workplace. We're going to talk about layoffs. We're going to talk about when people can come back to work. We're going to talk about what do we do if somebody doesn't want to work or can't work, et cetera. Before we get started, though, on behalf of Miller-Johnson, I want to say that this rapid spread of COVID-19 has raised a number of legal and business concerns for all of you in our community. And at Miller-Johnson, we believe we can best address those concerns by working together with you, with our government, with our community organizations, and with other professionals. And that's why we've put together this COVID-19 resource for all of you. And we do that with the eye toward practicing and living in a community that prizes collaboration, intellect, loyalty, candor, and ingenuity. And those are our daily guiding principles as we navigate these waters that are so uncharted with all of you. So please pass on all of this information and resources to your friends, colleagues, etc. This is meant to be something available to our communities, both throughout West Michigan, throughout Michigan, and now I think we're reaching even lots and lots of folks in other states too. So thank you for joining us. And with that, I'm going to pass the baton to Sandy to kick off question number 10.
Perfect. Well, good morning, everybody. My name is Sandy Andre, and I am an associate here in Miller-Johnson's Labor and Employment section. And as Sarah mentioned, yes, 3 weeks ago today, we kicked off this webinar series, but how the world has changed, and the questions we have been getting from our clients have changed. And so we want to revisit those pieces and make sure that we're addressing your most burning questions. So question number 10, old question, is this a pandemic? Now we're talking about, what do I do if an employee has a confirmed case? Next slide, please. And so what I'll start off by saying is we are going to be having a webinar next week completely devoted to what the protocol should be when you have a confirmed case in your organization. So that's the good news. But we'll hit the high-level pieces here. First of all, perhaps, right, this question is more of a when and not an if, right? We know the statistics in terms of how quickly it's spreading, particularly here in Michigan. Here in Michigan, we are one of the top 3 states with confirmed cases. So it's really important that an organization spend some time on the upfront developing what their written protocol would be. So when that time comes, it's simply a matter of following the process you've already outlined and hopefully had the opportunity to do some communication and maybe even a little bit of training on, right? So obviously then it will be really important to communicate specifically with your employee, communicate with leadership, and work very closely with local health officials. Essentially at that point, it's getting the employee out of the workplace and working with local health officials and within your organization to determine specifically who, right, what other employees, visitors, clients that infected individual has had close contact with in the last 14 days. There are some ways to mitigate that, and we'll talk about that in the next question, but it's important for you to know that the local health department will likely be coming to you as the employer asking for names and contact information. And so it's really important as soon as you, an employee communicates to you that they've had a positive test or they're leaving the workplace because they're experiencing symptoms and they later tell you about a positive test, it's important for you to begin that work right away to obtain that information. It's also important then that you will communicate to the impacted employees, right? So the individuals that your infected employee has had close contact with, making some communication to those individuals and sending them home to self-quarantine and self-monitor symptoms for 14 days from the date of their last contact. Next slide, please. So in terms of, so that's the communication you have with the infected employee and the communication that you have with the close contacts to the infected employee. But there also needs to be some follow-up to the rest of your organization, right? So you're going to want to notify all employees in writing that you have had an individual in your workplace who's tested positive, reiterate that your employees' safety is the most important, reiterate to your employees what you have been doing in terms of we have identified individuals who have had close contact with this person. We are working closely with the local health department, and we are following CDC and local health department guidance in terms of cleaning and disinfecting. You need to reiterate to your workforce why your operations are critical and important, because certainly we are all human and we can place ourselves in the lens of the employees, right, who are getting this letter, and there's a high freakout factor, certainly, and we can all understand that. So the importance of the communication to the wider workforce at that point is to communicate to them the things that you are doing to mitigate the risk to the rest of the workforce, and the things that the communication you are having with the infected employee and those within close contact to that employee to support them in their recovery and staying safe as well. An additional piece here, your obligations for confidentiality don't go away, right? So just because you're notifying your workforce that an employee has tested positive and you are working to identify those close contacts, you need to keep in mind your confidentiality obligations to the infected employee. And so that's important to keep in mind as well. Next slide, please. So when we talk about cleaning and disinfecting, we point you back towards the CDC guidance on this piece, okay? And so if the employee has been in the workplace in the last 7 days, you're going to want to completely close off areas that employee used until those are cleaned, and you'll want to start to evaluate whether stopping operations until a complete cleaning is feasible. And so that's going to be obviously very work site specific, right? So perhaps if you are an office building and you only have folks who are necessary to minimum operations, so there's very few people in the workplace and everybody stays in completely different areas of the office building, it may make more or less sense to be able to do a complete shutdown as compared to if you're a critical infrastructure organization still running manufacturing activities, and evaluate the ability to close down, but also what mitigation strategies you've taken to potentially contain the infection already as you evaluate whether you need to completely stop operations. And then lastly, you'll also want to start to consider additional screening measures of all of your employees, okay? So by now, we're all pretty well schooled on what those COVID-19 symptoms look like. And depending on where your organization is located, some of these additional screening measures may already be required for you based on the type of business you have, or depending on the location of your organization, right? So a number of localities say you have to complete screening of your employees and any visitors who come onto your property every single day. Some are requiring temperature checks of those individuals, so that you're denying entry to anybody who exhibits any of those symptoms, again, as a matter of containing the risk to the workforce that is still in your building. Again, you'll want to make sure that you're asking all the right questions of your employees to determine if they've had exposure to any confirmed cases, and wanting to ask about travel, right? Travel from areas with high infection rates. And, 3 weeks ago, we were talking about only a few areas with high infection rates, those level 3 travel advisory type of locations. So those have changed significantly, so it's important to keep those top of mind as well. Next slide, please. Okay, number 9, old question, how do I keep it out of my workplace? It shifted to the lens we're looking at now. What are safety precautions? What are the safety precautions I need to take if my workplace is still open? Next slide, please. So that stems from the fact that more than 30 states now are under some kind of what I'll kind of term colloquially as a stay-at-home or shelter-in-place order, right? So those orders are different from jurisdiction to jurisdiction. Even certain counties within states have their own that are a little bit different than the state stay-at-home orders. So they all vary a little bit, but generally, those orders will have some information about the level of operations that are allowed to continue and the type of employees that are allowed to continue on site, in addition to saying, hey, employers, if your work site falls into one of these categories and you've got folks on site, there's some additional things that you need to make sure you are doing to contain the risk in your workplace. So that is exactly what we have here in the state of Michigan. We are talking about Executive Order 2020-21 that discusses if you are a critical business and you are staying open with folks on site, there's a number of social distancing and mitigation strategies that you must implement. And so those are listed here. Restricting the number of employees you have on the premises to no more than is absolutely necessary. And so there you probably need to start looking at staggered shifts, staggered break times, staggered lunch times, maybe even creating new shifts, right, nights or weekends, to help separate the workforce, give employees scheduling options that they can help manage new family obligations as well. Promote remote work to the fullest extent possible. In fact, our executive order is pretty clear about the limitations on the folks that should be on site. Keeping employees and patrons at least 6 feet apart to the maximum extent possible. And so again, we talk about that needs to be including break times and coming to and departing the workplace. So looking at all of those points of time and locations of time in your workplace where folks might congregate, and thinking about ways to minimize opportunities for that to happen. Increasing cleaning and disinfection standards, and adopting policies to prevent employees from entering if they're displaying symptoms or have had close contact with known or suspected cases. And so as you look at the folks who are on site, it's important to think about opportunities, again, to limit movement within your facility, maybe even zoning your workspace and prohibiting employees from wandering into zones where they're not needed to perform their jobs. And essentially that's just a strategy for if and when you have an employee who has tested positive, it's easier to identify people who have had close contact and evaluate the places in your workspace that person has had, that person has traveled while they've been working, so that you can evaluate what areas need to be cleaned and if areas need to be shut down. Next slide, please. And so when we look at required safety precautions, again, you'll hear us time and time again that we really look to the CDC guidance for best practices here. Obviously, we'll want to take the opportunity to promote hand washing, encouraging respiratory etiquette, right? Discouraging shared use of phones, desk equipment, having sanitizer and wipes on hand, all of those pieces. Again, immediately isolating any employee who shows symptoms or who discloses symptoms to you, and then considering engineering controls such as high efficiency air filters, increasing ventilation rate, physical barriers like sneeze guards, right? One of the places that are still open are grocery stores, and we're certainly seeing those more, you know, at the checkout areas. And so thinking about engineering controls that you can put in place that represent physical barriers to limit potential exposure. Next slide, please. Again, other safety precautions, we talked about these a little bit, considering employee health assessment and even visitor assessments prior to entry. Again, we have some counties here in Michigan that these are now being required. Oakland, Washtenaw, and Ingham are examples, as well as different types of employers, so healthcare facilities as an example, and here in Kent County, daycare facilities are required to do some kind of screening assessment before folks can come into the facility. And then, of course, you're going to want to think about what PPE, personal protective equipment, you have available. Of course, employers, you're required to provide the PPE necessary for your employees to do their job safely. So that's a requirement under our occupational safety and health standards. But depending on the hazard and the worker's ability to follow those social distancing requirements, you might want to think about what differences there are there, right? So we've seen a lot in the news about masks. I think, 3 weeks ago when Sarah and I were talking to you, we were just starting to have questions about, hey, my employee does not need a mask to perform their job, but they want to wear one in the workplace. Is that okay for us to do? Should we say yes? Should we say no? And we talked a little bit about that time that there is an occupational safety and health regulation that says if you have an employee who wants to wear a respirator, right? So we're talking about fit testing type of respirator in the workplace that isn't required of their job. The employer then has some obligation to make them aware of the occupational safety and health standard on that, which essentially says, hey, employee, you're in charge of making sure it's clean and that it fits you correctly, and understand that these types of masks aren't recommended for everybody with certain types of health conditions. And so fast forward now, right, there's some comfort for employees to say, hey, I understand I'm part of the critical infrastructure. I understand I'm a necessary person to be here on site, and it would be a comfort to me, to have a mask in the workplace. And so it's balancing those things, right? And so we're seeing hand-sewn masks becoming popular, work sites providing gloves. Certainly, when I go to the grocery store, I see a number of patrons, right, not from a workplace standpoint, but just folks out in the community, they're certainly becoming more comfortable with this. In the view of employees or citizens generally, it provides a layer of protection. And so that's something to consider as well. Okay, next slide. Number 8, we previously talked about should we impose travel restrictions, but now we want to talk about what if travel is necessary for our operations here at our specific workplace or the work that we do. Next slide, please. So One thing that hasn't changed is our recommendation that we'll always point you back to the health notices that the CDC has issued. Now, the notices they have issued have changed certainly in the last 3 weeks, but we're always going to point you to that as the resource as you start to evaluate whether you should be restricting travel for your critical infrastructure business and your minimum necessary staff, right? So really evaluate if international travel is necessary. Certainly the CDC recommends avoiding all non-essential international travel, but if it is necessary, you're going to want to educate your employees on social distancing and other protocols to minimize the spread of infection. Make sure that your employees know that they cannot travel if they are sick, and then you are going to want to build in, right, to the regular rhythm of your workplace, folks coming back from international travel that you're still saying is necessary, that you implement this 14-day kind of self-monitoring quarantine period so that you can make sure they're monitoring for symptoms and they're not coming back into your work space as potentially infected. Next slide, please. Again, the link there for the CDC travel notices. And it's important to note, right, that this is changing. And in fact, there's domestic travel advisories, at least for 3 states right now, New York, New Jersey, and Connecticut, okay? And so the CDC has made some recommendations there. But remember, if you are part of the critical infrastructure, right, and at least in Michigan, everybody who's listening to us here hopefully has done that analysis, right? So we know if our business falls into that place. And so not restricting travel to those pieces, but having advisories. So, and again, discouraging travel in your organization to any location where COVID-19 is spreading. And that is based on CDC recommendations as well. Next slide, please. But as a practical matter, it's important to take the time to really evaluate, is travel truly essential? And the answer to that can be yes, right? So Sarah and I were talking yesterday that there was a client who had, a large shipment arriving from somewhere with a travel advisory, and that included having personnel from that location come and installing the equipment and educating the workforce on that equipment. And so sometimes those pieces are necessary. So again, just reminding you at that point, it's really important to implement what that travel protocol is and be communicating that back to your employees so that they know what to expect, okay? So, hey, employee, we're expecting you to do this, and just so you know, this is what we're reminding you about while you're gone in the behaviors that we want you, we're talking about respiratory etiquette, social distancing, those pieces. These are the things we want you to do during your trip, and when you return, this is what that's going to look like for you, right? So we're going to give you a health assessment upon your return and considering having you work from home or self-quarantine for a certain period of time, even if they haven't gone to one of those CDC identified higher risk areas. Anything that you can do to minimize the spread is what's important to consider practically here. Okay, let's take a pause here. Sarah, have we gotten any questions?
Oh, we sure have, and I'd like to answer some of them. The first thing I'll say is we have a handful of questions about the various tax and loan program, tax credit and loan programs under the CARES Act, and in particular, the Payroll Protection Program. I'm going to direct you to the webinars we did earlier in this week called CARES Act by the Numbers, and my colleague Eric Stark did 2 successive webinars talking in depth about that. Quite frankly, he's way smarter than I am and knows that stuff better than I am. So he's going to be more qualified. And I bet if you listen to those, he will answer your questions. So we had a question about travel that was not necessarily about business travel, but about personal travel. And the question is, with spring break coming up and employees maybe still going on trips or traveling, how should organizations handle that? Can we treat someone who traveled to a hot spot differently than someone who traveled to a less affected area? Great question, and boy, it really highlights the different place that we are in right now. 3 weeks ago, it seemed a little absurd that employers would be telling people that they could not engage in personal travel, they weren't allowed to, or that if they did, maybe they couldn't work right away when they returned. That is not where we are now, guys. If you have employees who are seriously considering still traveling, doing non-essential travel, I think the first thing you and that person needs to understand is the CDC is highly recommending against that. And that is because the CDC is saying you shouldn't travel to any place where this is spreading rapidly, and that is just about everywhere in the United States right now. If you have an employee that is going to insist on disregarding the CDC's recommendation in that regard, then yes, you can absolutely take whatever measures you think are necessary to protect the rest of your employees in your workplace. And that could include telling that person, if you go, you're going to be sitting at home unpaid for 14 days after you return. Can you treat somebody differently depending on where they go? I suppose you could, although I'm not sure there's many places where COVID-19 isn't spreading rapidly right now. Maybe Nevada, I suppose, but I don't know if that's because tests aren't available, et cetera. So that's the answer to that question. We had another couple of questions about health screening for employees. One of them was, can an employer mandate an employee to seek telehealth services if screening positive for COVID-19 symptoms? So as I understand this, it sounds like the employer did a health assessment and that person had COVID-19 symptoms. Can that employer then require that individual to get some sort of medical treatment or diagnosis before returning to work? Yes, absolutely. There's no question you can require them to do that before they are allowed to come back to work. Should additional screening measures be used prior to a confirmed case? For example, taking temperatures. So as Sandy mentioned, that is becoming more prevalent for businesses that remain open because they're part of our critical infrastructure. So remember, many businesses are no longer open or are operating on a very reduced basis. For those that remain open, we are definitely seeing many of them taking that additional step of doing a health assessment or health screening before individuals are allowed into the workplace every day. And there are an increasing number of counties, particularly on the east side of the state, that are actually requiring that. The question is should, right? And I think that is going to depend on who you are, what your business is, the level of contact that your employees have with each other while at work, et cetera. Remember, if and when you have somebody in your workplace who ends up being a confirmed case of COVID-19. And I think Sandy's right when she says if you're still operating, that is going to happen probably at some point. You're going to want to be able to feel comfortable that you've done what you could to make sure that as few other employees are exposed to that individual as possible. So more and more, we're seeing businesses take that additional step of doing some sort of health assessment before people come into work. I will say, too, they're increasingly doing it, particularly after they've had a positive test. Let's see. Let's take one more. I'm going to get this question a lot, I think, and it doesn't necessarily touch on the content of our presentation today, but I'm just going to go ahead and answer it. The question is, did the DOL expand what an isolation or quarantine order is under the Families First Act, such that employees can get that emergency paid sick leave just because they're home, complying with Governor Whitmer's stay-at-home order. And those of you who have been following that issue carefully know that there was quite a bit of debate about that. And then the DOL issued a Q&A and made very clear that that was not the case. That happened late last Thursday night. We talked about it last Friday in the webinar. And this week, the DOL issued regulations that have some sort of confusing language in it. However, we feel very comfortable continuing to say Governor Whitmer's order by itself is not a qualifying reason for employees to get time off under the Families First Act or get paid time under the Families First Act if they're on layoff, either because the business is closed or there's been a downturn in business. In other words, if people are home because they were put on layoff or a business had to close because of the executive order, they still do not get paid time under the Families First Act. Hopefully that was clear and not more confusing. Okay, let's Sandy, why don't you continue and I'll keep watching these questions.
Great, thank you, Sarah. Okay, question number 7. Old question, when can I require employees to stay home? But now we're saying, getting the question, when can employees not stay home? So when can I require them to come to work? Next slide. So again, here in Michigan, we have Executive Order 2020-21, and that is our stay-at-home order that generally carves out an exception for workers who are part of the critical infrastructure and workers who are necessary to conduct minimum basic operations. So the only people who should be remaining on site at your workplace, at least here in Michigan, are employees who fall into one of those prongs, okay? And so also, in the executive order, employers were required to make those determinations and generally, I'll say, provide a designation to employees in writing by 3/31. So that was a couple of days ago, but there are some exceptions to the written designation piece for some types of employers. So generally, healthcare and public health employees, necessary government workers, and certain volunteers, those written designations were not required. But everybody else, you should be issuing those pieces, those notifications to your employees. So if you are listening and you have operations in another state, you're going to want to refer to your state or locality specific shelter-in-place or stay-at-home order to determine if you have, if you're an operation that would fall into an exception, or you have employees that would fall into an exception. Those orders vary a lot from state to state. And here at Miller-Johnson, we actually have a team, a whole team who's devoted to helping clients with this analysis for every state where there is such an order. And we have, over 30 states now have these types of orders, plus several localities. So we have experts here in each of those, for each of those orders, who can help you complete an analysis if you have not done that already. But generally, those are the only folks who should be in your workplace now. So when we look at the question, when can an employee not stay home? Only if they are a critical infrastructure worker or necessary to conduct minimum basic operations here in Michigan, okay? Next slide, please. So this next question, Sarah and I are going to do just a very brief overview, because we did a whole webinar on it last Friday about the various pay options that may apply to any of your employees who are not working. So in the previous slide, we just talked about that there should be very limited folks who are working on site. Certainly you can still have folks who are working remotely, but what about the host of employees who are not working at all, neither working on site nor able to work remotely? So let's evaluate that. Next slide, please. So you'll see us, if you've been following our webinar series here, this is a familiar slide to you, and our framework has not changed, okay? So we always want to start where we start to evaluate our pay obligations or pay opportunities to an employee who is not missing work. We always start with this framework. Why is the employee missing work? Because that's going to help us identify when we must pay, when we can pay, those pieces. Do any federal or state laws require us to pay for the employee not being at work? Do any of our organization's own policies require us to pay the employee for not being at work? And then depending on how we answer all of those pieces, are there any additional employee relations concerns that we should be considering before we make the decision to pay or not pay? So next slide, please. So certainly, from the time that we first spoke to you 3 weeks ago, there's been a lot of federal movement on certain paid leave types of provisions for reasons related to COVID-19. So we'll first start there. The list of federal laws here in terms of paid time, we now have the Emergency Paid Sick Leave Act under the Families First Coronavirus Act, as well as expanded FMLA, also under FFCRA, that provide paid leave to employees in certain situations. We also know that the CARES Act has passed, and in the CARES Act, in addition to the loan pieces that Sarah alluded to and that we'll refer you back to our colleagues' webinars as they've evaluated that, there's also federal pandemic unemployment assistance pieces there. So in addition to additional coverage for folks who've traditionally been eligible for unemployment under certain state plans. So here in Michigan, folks who have been eligible for state unemployment, they now have access to additional federal money, but also that federal unemployment expansion now applies to individuals who have not traditionally been eligible for state unemployment benefits, rather, and provides an avenue for those individuals to access the unemployment benefits programs if they have been also affected by specific COVID-19 reasons. And then, of course, under federal law, we also have protected leave, right? So that pay might not go along with it, but your employee has the ability to take time off on a protected basis, and that can be under FMLA and the ADA if leave is a reasonable accommodation. Next slide, please. Then, of course, we'll want to point you towards your state-specific laws. So here in Michigan, we have the Michigan Paid Medical Leave Act, right? That's certainly a number of reasons related to our current COVID-19 environment would hit the thresholds of being eligible reasons for paid leave under that law. And as I just mentioned, we have state unemployment benefits. So the federal expansion for folks who've always been eligible adds a $600 a week amount to what they would have been eligible for generally in Michigan, which the top was $362 a week, bringing that person's potential weekly benefit to $962. So if you've got a person who would have been eligible for the most in Michigan prior to the federal expansion, they're likely now eligible for $962 a week. So the CARES Act also, of course, extends the amount of time an employee is eligible for those benefits and extends to employees who have already exhausted benefits. So say you had an employee previously who was eligible for unemployment benefits prior to any business disruption because of COVID-19, and say they hit their maximum or they exhausted benefits at that time. Now with this federal expansion, they have the opportunity for extended benefits as well. But again, other state laws, it's important if you've got operations or employees in other states, it's important for you to look at those as well. A number of other states have done some different things with their unemployment benefits program, and some states have made changes to their existing paid sick laws to extend eligibility for those programs related to COVID-19 reasons, or change the eligibility for those programs. So for example, if it used to be only certain employees working, a certain number of hours a week, some states had made some changes there, and some states have even passed emergency paid sick leave type of provisions. So you will want to take a look at what your state is doing to see if any of those state protections apply to your employee, depending on the situation. Next slide, please. And then, of course, you'll want to evaluate your own paid benefits platform, okay? So if you have short-term and long-term disability programs, there certainly could be reasons related to COVID-19 that an employee has become eligible for those, so you'll want to evaluate that, as well as your existing paid time off programs, okay? So if you have an existing PTO program or a sick pay program rather, and vacation benefits, you'll want to review your policies to determine if folks who are not working right now have access to those benefits. And of course then, I think a week or 2 weeks ago, we were talking to you a little bit about opportunities for unemployment supplemental plans. But now again, with the federal expansion of CARES, even some of that analysis has changed a little bit, because those would only make sense to the extent that CARES doesn't provide additional benefits in those situations. Okay, next slide, please. Now let's look at reason number 5. Initially we talked about, should I discipline employees who can't work or who won't come to work? And now this question has changed to, when can an employee refuse to work? Next slide, please. And I'll tease this by saying that I believe we are going to be having a webinar specifically talking about this in relatively short order, but we'll give a high-level overview at this point, right? So it's important to recognize, remember when we talked about the framework for evaluating whether or if you should be paying people when they are off, same type of framework applies here. We should be evaluating why the employee is refusing to come to work, because a number of legal protections may be implicated in that analysis, and we want to make sure that we are not running afoul of any of our obligations under those laws. So let's just go through a list here. So remember, under the FMLA, if an employee is incapacitated by their own serious health condition or they're caring for an individual with a serious health condition, they are eligible for job protected leave from work. So even if that employee, right, is a member of the critical infrastructure, they have the ability to exercise their right under the FMLA to take job protected leave for a number of reasons. And so we'll want to, again, ask the question, why are they not coming to work, to evaluate whether it falls under the FMLA. Similar to ADA, under the ADA, of course, an employer can be required to give time off work to an employee for a disability, right? So leave can be a reasonable accommodation, telework can be a reasonable accommodation, all of those pieces. And so we want to, again, evaluate the reason the employee is not coming to work. Is it their own medical condition that hits the level of a disability under the ADA, and is that what is causing them to want to refuse to come to work? And if so, is there accommodation that would allow them to continue to do their job absent leave? And if not, leave is likely a reasonable accommodation in that situation. Again, here in Michigan, we have Michigan paid medical leave. If an employee is missing work for their own illness or illness of a family member, or reasons related to public health, right? All those reasons that are covered under MPMLA. If an employee has not exhausted the time that you've made available to them under that law, and they are saying that's why they are missing work, and they've followed your policy in terms of notification and documentation, all of those pieces that you already have, if they kind of check all of those boxes, they are able to miss work in those situations and have that time away from work be protected. Next slide, please. The big question here, right, generally, that we've been getting is employees have safety concerns. So we'll go back to our occupational safety and health standards here. Remember that those provisions, an employee cannot be disciplined for refusing to work where an imminent danger exists and a reasonable person would agree that there is a real danger of death or serious injury. So that hurdle, that threshold is pretty high. And what helps you as an organization in that situation is putting in place all of the things that we've already talked about, right? So nobody is in the workplace unless they are supporting the critical infrastructure or they are a minimum necessary person. And if you still have people in the workplace, you've done all of those social distancing and mitigation strategies, and you've thought about how to change shifts or limit movement within the facility. All of those pieces can help inform of the likelihood of risk generally, but then of course if you have an employee with some kind of underlying condition who has a specific concern, you'll want to evaluate that risk to them on a case-by-case basis, okay? So similar to the protections under the Whistleblower Protection Act. So here we talk about Executive Order 2020-21, and that here in Michigan is our stay-at-home order. So if we have an employee who is saying, hey, my employer under EO 2020-21 is required to implement these social distancing and mitigation strategies, and they don't, and the employee is alleging a violation of that, and that's the reason I'm not coming to work, that employee likely has some protections that we want to take a look at. Or if the employee believes that they've been classified incorrectly, right? So I don't believe I'm a critical infrastructure worker, or I don't believe I'm an employee who's necessary to minimum business operations, and so I'm going to refuse to violate that stay-at-home order. So we'll want to look at those reasons. Again, most of these we want to engage with the employee to understand exactly what their reason is, because that'll help inform us about what our obligations are, just generally to look into the concern, but also to make sure that we're not running afoul of those protections. And then finally, certainly under the National Labor Relations Act, if somebody, if you have an employee who is saying, who's engaged in protected and concerted activities, so I don't think we all don't think we're safe because XYZ is happening here, that could potentially have some protection around it under the National Labor Relations Act. So again, the analysis is just like for the pay piece, what is the reason the employee is refusing? And depending on that reason, is there a state or federal law that requires us to not take any disciplinary action if the employee refuses to come to work? And even then, we'll want to engage with the employee to see if any of those concerns can be rectified, but just so we understand what our legal obligations are and potential legal potential response needs to be to employees in those situations. Okay, I think we are going to take a break for questions if we have received any, Sarah.
Oh my goodness, we sure have. First, I did indeed successfully confuse everyone about whether the Families First Act now is broadly available to employees because on the theory that Governor Whitmer's stay-at-home order is a quarantine or isolation order. So let me go back and see if I can talk about that a little more, and I will tell all of you that this is also maybe an analysis that you want to do individually with an attorney to just decide what's best for your company. But let me explain to you why we believe the regs say that it doesn't, and let me separate two scenarios, okay? So if you are a business that is a critical infrastructure business, you have work for those people to do, and they are not subject to the quarantine or isolation order. So in that case, that first reason for the emergency paid sick leave under the Families First Act would not apply, because Governor Whitmer's order is written to say that employees are not subject to the stay-at-home order if they've been designated to work for a business that is part of the critical infrastructure. So I'm getting a lot of those questions. If I'm part of the critical infrastructure, can't my employee then stay home because they're subject to the order? We think the answer is no, okay? On the other hand, if you are not part of the critical infrastructure and you don't have work to do for that employee because you're not part of the critical infrastructure, therefore the executive order forced your business to shut down, the regs are very clear that that individual does not get paid time under the Families First Act. So that's sort of unpacking our analysis of the regs. I think that if our Michigan executive order had been written differently, and I won't go into details about that analysis, if it had been written differently, then employees in Michigan might have that argument, okay? So if you have employees outside of Michigan, then that question is going to be decided by exactly how those executive orders are written. Okay, let's take some more questions. I got a handful of unemployment questions, and I want to cover those for a minute. One of them was if we have employees that are filing for unemployment for lack of work, but we still have some duties we need them to perform that are critical to our business. In other words, it sounds like maybe this person's been designated and might get called back to do some work here or there. Can they still get unemployment benefits? The answer is yes. They can certainly apply They'll get whatever's available to them in Michigan, up to a maximum of $362 a week, plus the $600 from the CARES Act. But then when they call and designate or call the Marvin system, right, and designate those unemployment weeks in which they worked, they need to disclose the wages that they earned during those weeks. And then their portion of Michigan unemployment benefits will be reduced accordingly, and that'll just depend on how much money they made that week. So you can have somebody on unemployment that comes back and does some work for you now and then. Does an employee that's been on unemployment prior to the COVID-19 business disruption, are they eligible for the $600 additional benefit? We believe that answer is yes, if they are an employee that would otherwise be eligible for unemployment in Michigan. On the other hand, if they're an independent contractor or a gig worker, they only get benefits if it's for some sort of reason connected to COVID-19. Another question, we closed specifically due to the stay-at-home order. Our employees immediately filed for unemployment. Now, what is our obligation? You have no additional obligation. Those employees, if you closed because of the stay-at-home order, those employees do not get the paid leave under the Families First Act, and they're doing exactly what they should be doing, which is pursuing unemployment benefits due to a lack of work. Couple of questions about what if an employee is just afraid to come to work. Hang on, that's our next question we're going to cover in the presentation. So hang on to that thought. Let me scroll down. There were a couple more that I wanted to answer. That one. What if an employee has exhausted FMLA? Do they still get any of that emergency FMLA under the Families First Act? And the answer is no. That FMLA time under the Families First Act comes out of their general FMLA bank. So that's all considered together. It's that 12 weeks in an FMLA leave year. And I've gotten that question several times for clients with maybe employees who were intending also to take FMLA later in the year. And it's true, if they use that time now under the Families First Act, that is going to impact how much they have to take later in the year. Okay, let's hold there, Sandy, and I'll keep track of these questions and come back to some of them, okay?
Perfect. Okay, let's go ahead and go to reason number 4. So remember a couple of weeks ago, we were evaluating whether an employer could require a medical certification to allow employees to return to work, but now the question is, should you? So go ahead and next slide, please. So let's first talk about if we have an employee with confirmed or suspected COVID-19. Again, we'll point you to the CDC guidelines that talk about when it would be appropriate for that employee to re-enter the workplace. And that standard, no fever for at least 72 hours, so 3 full days with no fever without use of medicine that reduces the fever, okay, and other symptoms have improved and at least 7 days have passed since your symptoms first appeared. So as we're looking at when we should even let an employee come back, that's the standard for a confirmed or suspected case. If we have somebody who is just showing symptoms, the CDC guidelines talks about being symptom-free for 24 hours. So that's the situation when we should even think about letting somebody return. Next slide, please. But now let's talk about what we should make them bring with us. And so if you are dealing with an employee with a confirmed or suspected case or somebody who has exhibited symptoms and they're ready to return because they hit the requirements in the previous slide, certainly the EEOC is now supporting any medical inquiry that you need as the employer to protect the rest of your workforce against COVID-19. So that's no longer a concern. Our last conversation, we evaluated that a little bit more, but that is fine. And you've got to think about the employees in your workplace. Remember, several slides ago, we talked about the communication you would need to do when you have an employee who's a confirmed case, because you need to be communicating to your workforce because their safety concerns are extremely high. And so we want to do, as the employer, you want to position yourself to be able to reassure your workforce that you're doing what you need to do to keep everybody safe. And so we recommend folks in the confirmed suspected having symptoms camp. Before you let them come back to work, you should be requiring some kind of certification for that individual to come back to work. If you remember, initially the concerns were, hey, our healthcare system is going to be taxed dealing with COVID-19, and so, hey, employers, please, as a practical matter, do not require this of your employees. However, now what we're seeing is many medical offices appear willing to provide that information to employers because the majority of those offices have closed or have limited operations for non-emergent reasons or reasons not related to COVID-19. So kind of colloquially, that's what we're hearing, is that there is the ability and certainly the willingness from those offices. And again, the content of a certification, it doesn't need to be elaborate, right? We don't need somebody to fill out, kind of the certification form for FMLA. We're not looking for that. It's essentially just the critical information that we need. Hey, it's safe for the individual to return to their job, to this workplace. And that information is going to be very different depending on the business and the position, right? So if, the example I gave earlier, if we're talking about an office environment and there's only 3 people on site because they're necessary to continuity for business operations, or they're on site because they allow everyone else, they're critical in making sure that everyone else can work remotely. Again, and those folks work in completely different places of the building. Again, the risk is a little bit different than if we're talking about returning this person to a manufacturing line, where even though we've instituted those social distancing and mitigation strategies, there's a lot more people here in the workplace, and even folks that person may come in contact with just as a natural piece of their job. So it's not such that every person who is now symptom-free is able to return. It's still going to be fact-specific, okay? Next slide, number 3. What should I do if employees are afraid to come to work? So this is what Sarah was just talking about. So go ahead and go to the next slide. So a big important piece, right, is I'll turn you back to question number 5. So really evaluating, right, what is the reason that the employee is expressing fear? Dig into that a little bit so that you understand your legal obligations. If somebody says, I'm afraid because I have a serious health condition and I want to take leave, that could implicate FMLA, right? And you're then legally obligated to provide them leave. So you want to dig in on the reason to make sure federal or state law gives them protections to not be coming to work. But generally, what's important here is communication, right? So you want to be communicating to your employees that their safety is very important to you, and you want to make sure that your actions, and when I say your, I mean leadership, organization, your actions reflect those words. And so that all goes back to What are you doing in your workplace to ensure employee safety to the extent that you can, right? So here in Michigan, again, let's talk about folks who are still working on site, right? They're part of the critical infrastructure, or they are part of the group who are necessary to minimum business operations, right? So we want to be communicating to our employees, hey, employee, you have been deemed an essential worker. So talk about why your organization's work supports the critical infrastructure, why you have deemed that employee so important to that work. Most of you should have been doing that under the EO, right? You needed to make those written designations. But even if you were an organization that wasn't required to do those designations, this is a great time to communicate that, to make sure employees understand why they are still there. Then you're going to want to articulate, again, all those reasons. What have you done to help minimize the risk to your staff? What are the social distancing and mitigation strategies that you have put in place? For those who are subject to either an executive order or locality order or a public health order requiring employee screenings or visitor screenings, it's important to, tell your employees that in addition to these social distancing strategies, we're also complying with, an executive order or public health order that requires us to screen all of our employees, and we're not letting people in our building who are showing these symptoms, and we're not letting them return until they are symptom-free and they receive a medical certification, all of those pieces, okay? And so just reiterating all of those pieces. And so at the end of the day, let's just say you do all that, and an employee still says that they are afraid to come to work. And so we don't have a legal concern, right? So if we go back to answer number 5, nothing is implicated there. We've communicated all of those things. Maybe it makes sense at that point to weigh your organization's ability to offer an employee an unpaid leave instead of termination, right? So none of us can make any employee come to work. That was true before COVID-19. It's going to be true after COVID-19. And so, generally maybe that would result in termination, but maybe this situation begs us to at least analyze whether we have the ability to offer an unpaid leave in that situation, right? And so that's going to be organization and job specific too. Now, in theory, an employee who says, I'm just afraid I'm not coming, and you've done the analysis, they're supposed to be in the workplace, we've done all of these things to minimize risk where we can, that person should not be eligible for unemployment benefits if their fear, if it's solely fear-based and work is available, right? In that situation, they should be viewed as refusing suitable work. However, this is a rapidly changing situation, and we are not entirely clear what the employee unemployment insurance agency would do in that situation. However, the process for contesting unemployment benefits is not changing, right? So you will have the opportunity to contest, and what comes in handy here, right, is showing all of those communications you've had with your employees, that interaction you've had with them about what you've done, how you've minimized the risk, why they're important. All of those pieces will be important in that to contest the employee's ability to tap into benefits in that situation. Next slide, please. How do we handle layoffs and what is a furlough? So initially we were talking about what do we need to do if we need to shut down operations, but now we're talking about, hey, I need to do a layoff or a furlough because work isn't available or whatever the situation is. So next slide, please. So we'll tease this a little bit by saying this will also be the subject of an upcoming webinar, but we'll generally lay out the process you should follow as you evaluate what makes sense for your organization. So first, you'll want to identify the impacted areas of your business. So what areas of your business no longer have enough work to support continuing operations or operations at full strength type of level. Then you'll want to establish, okay, within this group of people, how am I going to select, if it's not a wholesale, everybody in the group, right? How am I going to select who stays and who goes? And of course, we're going to want to make sure that those selection criteria are related to business reasons and not discriminatory reasons, right? Then we'll want to talk about and think about, okay, is this layoff or furlough, whatever terminology your organization uses, is this going to be temporary or permanent? Because we will want to evaluate how benefits potentially flow from that and use that to craft our communication. We'll also want to consider if we are an organization who wants to take advantage of some of the economic relief benefits under the CARES Act. We want to make sure we understand the potential implications for any type of loan forgiveness if we decide to make layoff and furlough decisions before or after we access that money. Next slide, please. Depending on the size of your organization and the type of downsizing you are going to be doing, you may be subject to certainly the federal WARN Act, but there are many states who have what we call a mini WARN Act, that employers of a certain size who are doing mass layoffs or a certain number of employees are impacted at single locations. You have obligations to notify your workforce and provide them some very specific notice requirements, as well as notify government officials of those layoffs. Of course, then we'll want to draft the layoff communication to the impacted employees and make sure that you have a process to obtain updated contact information for all of your employees with the eye towards as we look into the future and this crisis ends and we have the ability to ramp back up, we want to be able to reach out to the folks who we have had experience with, right? They're good employees and we want them back. They've already been trained. That's the pool we want to tap into first. So making sure you have some mechanism for obtaining contact information. Next slide, please. Now let's talk a little bit more about what those layoff communications should look like, okay? So we want to be clear about the reason that this employee was selected for layoff. And again, if it's just a whole group, it certainly can be, you know, economic impact related to either the stay-at-home order or whatever the situation is, okay? Want to communicate to the employees whether we anticipate this to be temporary or long-term, and how this will impact their benefits, right? So is health insurance continuing, or are we going to continue, do we have the ability with our carrier to continue those benefits? Under our plan, do we have the financial ability to be able to do that? Are we going to do that? All those pieces you'll want to firm up. But then, of course, you're going to want to provide them unemployment information. And at least here in Michigan, there's a couple of specific forms that are really helpful, right? So you'll want to make sure that you're including those communications and then just provide them some additional information that makes it easier for that employee to apply for benefits as soon as they are able. Different states, again, have different requirements here on the unemployment front. So be sure to evaluate wherever you have operations and your employee is located. Make sure you're evaluating what your requirements may be in those states. Next slide, please. And we will say, number one question, this one hasn't changed, and our recommendations generally haven't changed either. What should I be communicating to my employees right now? Next slide, please. So like we talked about 3 weeks ago, leadership is so important here, and your goal is, as you continue, as we all continue to navigate this space that we are in that's filled with so much uncertainty, your goal is to demonstrate the knowledge that you have, instilling calm and confidence among your employees. So reiterate to folks that safety is your highest priority. Unless you have reason to think otherwise, reiterate that you do not believe there's any immediate risk or cause for concern, either for the folks who remain on site or for the folks who are working remotely. And again, detail what your organization is doing to limit those risks. So you have complied, as an example, you've complied with EO 2020-21. The only folks that remain on site are folks who fall into, two buckets, the critical infrastructure folks or the minimum business continuity folks, right? And everyone else is working remotely, and here's how we're doing all of those things. Maybe you are taking extra cleaning measures and you're following CDC guidelines on that. Talk about the social distancing measures you've put in place. So we've changed shifts, or we've limited the locations in the workplace where people can travel that aren't related to their job. All of those pieces, if you've instituted health assessments, reiterate those pieces. Next slide, please. Remember that if you have employee dignity policies or anti-bullying policies, that you continue to enforce those policies, right? So we don't want employees being discriminated against because they have some association with somebody who is tested positive or traveled to a certain area or any of those pieces. So reiterate your commitment to the employee dignity expectations in your workplace. Again, reiterate that the situation is fluid. Every day is a little bit different, and continue to communicate to your workforce that as new information becomes available, you are continuing to evaluate that as it relates to your business, and will make the best business decisions you can to keep your workforce safe. And then, of course, identifying a resource that your employees should contact if they have questions. As much as you can, you'll want to have some kind of centralized communication function so that we can make sure our employees are getting consistent communication. And folks who are involved in evaluating, an employee's request to work from home, when you think that they are part of the critical infrastructure, right, you're going to want to make sure you have a central type of person, right, who's evaluating that in a consistent manner. So, Sarah, that takes us to our last slide. Any new questions?
Yes, we have a couple of groups of questions that I wanted to address. The first one involves COBRA and health benefits for employees who are not working, whether it be because they're on layoff or whether it be because they're home on quarantine, et cetera. And put broadly, the question is, how long can I keep them on my plan, and when do I have to put them on COBRA? The answer to all of those questions is that it depends on what your plan says with regard to how long employees can stay on when they are not actively working. Many plans have a distinction between employees being on a leave of absence versus being on layoff. Okay, so you want to start by pulling out that plan, making yourself familiar with that plan. And I will also say many carriers, including Blue Cross Blue Shield, have said that they are willing to expand those plans, expand coverage for employees who are off work for a variety of COVID-19 reasons. So start by understanding what your plan says, and then reach out to your insurance agent and or the carrier to ask what, if any, exceptions are being made or extensions are being made. We had a lot of questions about what do I do for an employee, or with regard to an employee who doesn't necessarily have a positive COVID-19 test but has displayed symptoms. Do I treat it like a positive test and take all of those actions that we talked about in response to our answer? Do I do something short of that, et cetera? And of course, that's probably the more common occurrence because testing seems to be limited here. So we have lots of employees who have symptoms, may have a suspected case. A healthcare provider may tell them they're pretty sure it's COVID-19, but we're not going to test you, et cetera. And I think what you do in those circumstances, again, is going to depend on the facts. In other words, is this an employee that just has a sore throat and a headache, or is this an employee for whom a healthcare provider has indeed said, this is a suspected case of COVID-19. I'm assuming it's COVID-19, but we're not going to test them. Those are two very, very different circumstances. And it's going to depend on the level of safety concerns in your workplace right now. It's going to depend on what your workplace is, et cetera. So you're going to take those, I'm sorry not to have a black and white answer for you guys on this one. You're going to take those on a case-by-case basis. Now, I will say, I believe that in those cases in which a healthcare provider has indeed said, this is a suspected case, or I believe this is COVID-19, I would encourage you to consider treating that as if it is a positive COVID-19 case, because that information is likely to get back to coworkers and your employees. I think it's much different, on the other hand, if you have somebody who had a fever for a day, or maybe had a sore throat, or maybe had what we think instead is a cold. No healthcare provider is saying that they actually think it's COVID-19. That's very different, and I think you have a lot more latitude to instead apply the, you got to be symptom-free for 24 or 72 hours, depending on how conservative you want to be, and go ahead and let that person return to work. I had a handful of questions about when employees can get unemployment benefits if they're off work, not due to a lack of work, in other words, a layoff or a shutdown, but because of COVID-19 reasons, and whether the unemployment agency is going to give them benefits. Let me tell you what the executive order says about when those folks should get unemployment benefits first. What the executive order says is that they are only supposed to get unemployment benefits if they've left work involuntarily, or they're on a leave of absence because they're self-quarantining in response to an elevated risk because they're immunocompromised, or because they're displaying the symptoms of COVID-19, or because they've had contact with a confirmed case, or because they're needing to care for somebody who is a confirmed case, or they're staying home with their kids because school or daycare is closed. Now, you'll notice a general fear of COVID-19 is not one of those listed reasons, okay? So we do not believe the unemployment agency should be giving individuals unemployment benefits because they have a general fear of leaving their home, and you have worked for them to do. Now, I can't promise that the unemployment agency isn't going to give them benefits anyway. I cynically think the unemployment agency doesn't possibly have the staffing to sort through these claims, and that they're probably just going to approve everything. And then it's going to be up to your business to decide what to do about that when you get the notice that those employees have been found eligible for unemployment benefits. You do have the ability to dispute it at that point if that's what you want to do. So with that, I'm going to sign off here because we are well after 9. I know we have a handful of additional questions, and we'll do our best to be answering those in upcoming webinars. And I'll also say to folks, look back on our COVID-19 page. at the webinars we've done, because a lot of your questions, I think, are answered by those as well as our client alerts. So thank you so much for attending the Friday morning webinar, and we will be talking to you guys soon. Thanks.